or before the learned single judge, and in the first round before the division bench.
You might have to perhaps go against the person who has sort of done you in, but then he is taking advantage of what is called forged building permission, etc.
I'll answer that.
It is not for you to answer.
No, since we are purchasers of the property, little bit information that we have.
Definitely party to that forgery.
No, I am not.
You are also a person deceived by the builder.
By the builders, certainly. Now, how the problem is that since the landowners, there is no dispute on the ownership of the land. That is with respondents 10 to 14. They enter into a substantive development agreement. There is also no dispute with that development agreement. It's on the strength of the development agreement that the building is constructed. Now, when the building is almost complete, one of the respondents who's the neighbor, immediate neighbor. So this property is AA59. He resides in AA60. He says there is an unauthorized construction. The municipal corporation says that the plan that the builder has produced on record, that has provisional sanction and renewal, but the corresponding entry only in their register is not matching with that plan. That is the only thing. Now, if the High Court record is to be seen, the builder and the developer says he has inspected the record of the municipal corporation. He finds that there is some overwriting in the register. Ultimately, the High Court division bench, the learned single judge dismisses the petition without calling for any affidavits. The division bench as also dismisses the appeal and says criminal proceedings against the builder. In this whole episode, the ultimate loser is the purchaser, of these flats. Ultimate loser,
No, correct. But then an unauthorized construction
with fake
documents.
No fake. The only thing is there is no
finding. If the finding is incorrect, then you'll have to go to the High Court.
So we go and review, which is the second order passed. Prior to passing any order, since we are in possession, before the demolition order was passed, at least the municipal corporation should have heard us. Now, section 266 of the West Bengal Municipal Corporation Act undoubtedly vests power in the commissioner to pass an order for demolition. But 287, which we have produced, also says that prior to passing the demolition, the owner of the property has also to be heard. At that point of time, when the conveyance is already executed, the developers actually have no interest. They may be pursuing that remedy to save themselves from criminal action or from action under the Consumer Protection Act by us. But they are not divested of all ownership the moment the deeds of conveyance are executed. So all that we said before the Honorable Division Bench was, let the Commissioner hear us. Maybe, if we are able to convince him on our plight alone, sheer plight.
For us.
Landowners are yet to come. They have 8 flats in the property. We have 12 flats in the property. That's how the development agreement is. So obviously, in all development agreements, the landowners keep some flats with them. Rest of them are sold by the builder. Builder also, I'm told there is an SLP pending, but it is in defect, I think. And therefore, if you kindly just see page 79, which is section 287. Prior to passing a demolition order, under 266, it is the owner of the property who has to be necessarily heard. All that I was requesting before the Honorable Division Bench was, let the Commissioner hear us. If he sees our plight, there are chances, if there is any way we can get it compounded or regularized, because only this is a question of sanctioned plan. It's not as if that the building is constructed on a water body or some environmental clearances are not there, etc. And that too, so far as sanctioned plan is concerned, so far as that register is concerned, yes.
If the construction is contrary to the applicable rules, floor space area.
To that extent, the demolition order doesn't say that it's contrary to the rules.
The foundation is wrong.
No, I understand, Lord. I understand that.
I'm sure this person would have asked your
Yes, certainly, Lord.
But the council.
No, I've asked him, Lord. And that is why I'm showing 287 at 79. Who's to be ultimately heard?
What is the answer you have got from your brief?
The answer is that the sanctioned plan.
Deviation.
There is no deviation per se in the building structure. What has happened is this. There is a sanction plan for this very property, which has got provisional sanction as also renewal. The corresponding entry regarding that plan does not match in the register of the municipal corporation, to which the builder says there is every possibility either of some clerical error there, or when he has inspected the records, there is a possibility of some error or some overwriting there in that register by someone.
Right.
Now, in their fight.
Have you been paying property tax?
No, we have just entered because it's May 23. The demolition order came in May 23. Our sale deeds are of January 23, April 23. So now, my lords, I think now we'll be asked to pay property tax, etc. or those details. But there are electricity connections in my name. Those bills are there. We cannot place them on record as well. This SLP, my lord, with great respect, has been filed quite hurriedly because we really don't have time. The demolition order can take place any day in view of the, my lords. But I'll place it on record, my lords.
Although there is a mismatch, where is that document? Is it available?
Your lordship wants to see the map, the sanction plan. Yes, I have.
The document which sort of permits the building construction.
I have it, lordship. What is the problem? My lord, I can just show it from here for a second, and then of course I'll pass it on. My lord, I'll just show it very clearly from here. Now this map has got a provisional sanction and a renewal for the same property to construct the same building.
When was the date?
One is 19th April 2011. Then the renewal takes place on 22nd June 2014. And under the Act, the renewal can, my lord, subject to permissions, go up to 5 years.
When was the construction completed?
My lords, in 23. In about, my lords, April 23.
And is it the case that the constructions have been completed beyond the first renewal?
Yes, my lord.
On a lapsed permission, is it that case?
My lord, that municipal corporation says that it is a lapsed case because we don't find a corresponding entry against this plan.
They can't say both.
No, that is what they're saying. My lord, if your lordship would see the division bench first order, they're saying that, Lord, kindly just have a plan, my lord, for a second. It is a sanctioned plan. The problem is, I'll just point out from the serial number 311, which is written on the top of the plan, the corporation says in our register there is no such plan. Now, by the time, my lord, this particular municipal corporation earlier is Rajarhat Municipal Corporation. By the time the matter reaches the High Court, my lords, Rajarhat Municipal Corporation is taken over by Bidhannagar Municipal Corporation, which your lordship would find in the impugned order, the first impugned order passed by the High Court as well. Their lordships will not have.
Chairman means elected representative.
I'm sorry, my lord.
Chairman means elected representative.
Please. Chairman is yes, my lords. And page 4, if your lordship would see the query that my lords are posing.
Personal sanctions.
However, the High Court, however, because of the mismatch
Please.
of the building plan, sanction plan, with the entries, corresponding entries in the Rajarhat Municipal Corporation Register,
Register, my lords.
comma, demolition order was passed. Stop. It is then pointed out that the concerned building that the developers within bracket respondent number 1 and 2 had constructed the building and they have sold 12 flats and as the share owners, they have handed over how many?
8 flats.
8 flats. And has sold the remaining 12 flats
To the petitioners.
to the petitioners. All the petitioners are here?
All of them are here.
To the 12 petitioners who are before the court. Stop. What is that provision you said?
Lord, page 79, your lordship would kindly see page 78, 79.
The Senior Counsel then refers to the provisions of Section 287 of the West Bengal Municipal Corporation Act 2006 to argue that in the event of demolition of any illegally constructed building, a reasonable opportunity of being heard to the owners of the building is a sine qua non. Sine qua non under the said provision. But here, although the petitioners are the owners of the flat, they have been denied such an opportunity. That I issue notice returnable in 4 weeks.
My lord, in the plan, may I indicate one thing which has been handed over to your lordship?
Yes.
My lord, your lordship would find the plan is a G+4 plan. Building which has been constructed is already G+5. That is on record.
That's okay. Then you may have to demolish the
And-
upper floor.
And my lord, moreover, my lord, this
You are appearing for who?
respondent number 7 and 8, my lord,
Neighbor.
adjacent
The
land,
neighbors, my lord. The neighbors.
adjacent landowner.
That's okay.
And my lord, it is not that they have challenged the order of demolition. They have straight away come up to the
They
review.
have to be given an opportunity at this stage when I am occupying a particular building, I am the owner. But without hearing the owner, you will be demolishing it.
My lord, it has issued notice to them.
Okay.
It
So,
was
municipal
attached in the
commissioner should hear them. That's all we are saying.
Oh. What have you constructed in your plot?
But I have constructed a building and it is with a,
No, is it a residential block or this is also some big apartments?
Residential block, no, it's multi-story. No, I've got the photographs. Just immediate adjacent is his property. So he had a dispute with the builder. The builder sorted out the dispute. Unfortunately, it's now snowballed into another further dispute between the builder and the corporation. And the ultimate loser is the flat owner. This is our property, my lords. The entire lane is purely residential. I've got
but page 81.
about 700, 800 multi-storied complexes are there.
But page 81.
I'll just point out. But
Stop work
the
notice.
first
was-
photograph is of the present apartment block which they wish to demolish. And Lordship may kindly see the lane. The entire area, my lords, is of identical constructions. This A59 is our property, my lords. Kindly just see, my lord, the entire lane. Both sides are residential properties.
But stop work notice was issued and it was pasted in the wall of that flat.
I have handed it over to my brother because the color of the building scheme, color scheme of the building is a bit jarring to my eyes.
Important question of law here, and which gravely affects the petitioner, who is a commandant in the border security force. Note, if your lordships kindly see, there is a right under the rules, under the BSF rules framed under the BSF Act, to file a pre-confirmation petition before, my lords, the findings and sentence in a general security force court, that is equivalent to a general court martial in the army. Before that is confirmed, there's a right to file a pre-confirmation petition. And if your lordships kindly just sees page F of the synopsis, not page F, lordship will see rule 167. The Army Act and the BSF Act have a similar section. Section 164 of the Army Act and section 117 of the BSF Act give this right to file a pre-confirmation petition. But the BSF has a further rule, which your lordship may kindly read straight away at page F, my lords. If I may read that note at the foot of page F. Army has no such rule equivalent to rule 167 of BSF. And if my lords, may I just read that note on the right-hand side foot of the page at page F, my lords?
167.
Rule 167. Petitions against finding and sentence of court. 1. A person subject to the act who has been tried by a court shall be allowed to put in one petition before confirmation to the confirming authority and one petition after confirmation to any authority specified in subsection 2 of section 117 or the Inspector General who shall be the prescribed officer for the purpose of that section. 2. In the case of a summary force court, he shall be allowed to put in one petition only to any one of the officers mentioned in section 117. So for a general force court, there is a specific right to put in one petition before the confirmation. Now, I filed the petition before the confirmation. What is important in my case is, out of 6 charges, my lords, 2 charges, charge number 1 and 3, were held to be, I was held to be guilty of charges 1 and 3. And charges 2, 4, 5, and 6, I was exonerated and it was found that those charges are not proved.
Yes.
The revision was then taken up by the Director General of the BSF, who's the senior most officer of the entire BSF, against that. And in the revision, I filed a pre-confirmation for the revision. The confirmation hearing is before the Director General, and the Director General can suo motu conduct a revision proceeding. Now, I filed a pre-confirmation petition, which under Rule 167 is to be placed before the confirming authority and is to be heard before confirming, so that he has my entire say on even on the 2 charges which were held against me, which were proved against me, as well as the others. Now, here what happens is, it is an admitted fact on affidavit before the Delhi High Court that the confirmation petition was not heard by him because he took up the revision suo motu, and he's issued a revision order directing the security force court to examine the entire thing and to re-examine the four charges on which I was acquitted or exonerated, and to consider holding me guilty of those four charges also and imposing a suitable punishment thereafter. Now, there are four courts, at least three courts, the Honorable Guwahati High Court, the Rajasthan High Court, and the Delhi High Court Division Bench, which have taken the view that under the BSF Rule 167, the pre-confirmation petition has to be heard by the concerned confirming authority before passing a confirmation order or before passing a revisional order. There are two judgments the Delhi High Court relies on against me, which are under the Army Act and not under the BSF Act at all. And Delhi High Court overlooks not the judgments, three judgments of the Honorable Guwahati High Court, Delhi High Court, and Rajasthan High Court, which are under BSF Act, and relies instead on the other judgment on the other act, and says there's no need to consider the pre-confirmation petition before issuing the revision.
How that point is dealt with?
Yes. If your lordships are kind enough just to see the page 3, the two judgments in para 3, their lordships are shown two judgments by the respondents, which are Naik Gyanchand under Army Act and Brigadier R.P. Singh under Army Act. The para 4, the Learned Counsel for respondents submit that post the report of General Security Force Court on revision, the petitioner would have a right to submit a pre-confirmation petition in case he is aggrieved by the findings of the GSFC court in revision. In rejoinder, Learned Counsel for petitioner submits that the judgments in Naik Gyanchand and Brigadier R.P. Singh would not be applicable to the present case, inasmuch as the court in these two judgments was considering the Army Act 1950 and the rules framed thereunder. He submits that there is no provision pari materia to Rule 167(1) of the BSF rules in the Army Act. He also draws our attention to the judgment of this court in Kiran Kumar versus Union of India 2023, Delhi. This was a division bench order, which is in Kiran Kumar. We have considered the submission made by Learned Counsel in Naik Gyanchand, this court, while considering 160.
Those are the Army Act.
Both Army Act judgments.
What about Kiran? Where has Kiran been considered?
Kiran, the learned judge, sets out certain provisions in revision in 160, etc. And then in para 13, para 15, I'm sorry, Kiran is specifically dealt with in 15, but if my lords could also consider 13 and 14. May I go straight to 15, lords, where your lordship?
167 is discussed in 13.
In 13. Then my submission on that is set out in para 14. Then in Kiran, in para 15, the learned judge says, in Kiran Kumar, the court had found that the pre-confirmation petition filed by the petitioner therein post the revisional order had not been considered by the confirming authority. It is in those facts that the court set aside the order passed by the confirming authority and directed the authority to first decide the pre-confirmation petition filed by the petitioner post the revisional order. The said judgment, therefore, cannot come to the aid of the petitioner in the present facts. Now, please see their affidavit in my case. At page 91 and 95, they categorically said the pre-confirmation petition was not placed because the revisional authority is revising and sending it back. May I just show the counter notes at page 91 and 2?
Don't you have a sort of a chance to challenge it and this application after the matter gets...
So what happens, my lords, is the Director General, being the senior most officer of the BSF, passes a detailed order and revision, all but directing the authority to find me guilty on the other four charges, where I'm exonerated. Now, I'm saying pre-confirmation is a right to be heard.
Right.
He must consider it.
All right. Heard Mr. Siu Singh, the inquiry. What is that inquiry?
The General Security Force Court, GSFC.
The General Security Force Court found the petitioner guilty of only charge number
1 and 3.
1 and 3, and had found him not guilty of charge 2, 4, 5, and 6.
And 6 minutes.
Stuff. At that stage, the petitioner had filed
a pre-confirmation petition.
The pre-confirmation petition under Rule 167(1) of the BSF rules. against the finding, guilty finding. Stop. The however, the revisional authority who is supposed to consider the said application,
Man,
the revision authority,
the confirming authority,
the confirming authority in the rank of
Director General of the Border Security Force.
confirming authority, who is the Director General of the Border Security Force, instead of addressing the said application under Rule 167(1), decided to take up the matter on the findings and ordered for a reconsideration of the finding.
He remanded it back to the General Security Force Court.
Remanded the matter to the General Security Force
Court
Court
to reconsider the exoneration under.
Consider the exoneration against the 4 charges.
Well,
Stop. The said procedure was faulty, as has been held by this court
by the Delhi High Court.
as has been held by the Delhi High Court in Kiran Kumar. Where is that Kiran Kumar ratio?
Look, that is it's at page 129. I've set out the judgment.
129 से देख लीजिएगा. Kiran Kumar.
129 para 8.
Para 8.
And may I also give Guwahati with the.
Yes, give Guwahati.
Just Kiran Kumar.
Yeah, all right. Just give it these 2 judgments. Stop. However, the London Division Bench adverted to 2 other judgments, i.e. Naik Gyan Chand or Brigadier R.P. Singh, which are cases arising out of the Army Act 1950, where similar provision, Army Act 1950, where similar provisions like Rule 167(1) of the BSF rules do not exist. ये जो 2 जजमेंट है ये आपको जजमेंट में मिल जाएगा. References. Stop. With the above projection, Commanding Council submits that the writ petition filed by the delinquent commandant should not have been dismissed in limine, as the petitioner does have a right, as the confirming authority has to consider the pre-confirmation petition of the delinquent under Rule 167 of the BSF rules. Stop. That I should notice.
There was a stay by Delhi High Court at page 76 all this time till my petition was dismissed. In fact, coincidentally, the same learned bench which had delivered the Kiran Kumar judgment had admitted the matter, issued notice and granted stay at that time. That has continued.
We will not record that.
No, that is only an aside. But at page 76, the stay order dated.
In the meantime, the interim order operating in favor of the interim order dated
13 March 2023.
13/3/2023 operating in favor of the petitioner will continue to operate.
Deeply obliged.
Please, it's item 52. It's a batch of about 40 petitions, Milord.
Yeah.
We have after notice. There are 2-3 things I may just point out at the outset. One, because as per the office report, service is not complete in some matters. I'm just
in some of these cases where respondent has engaged some lawyers.
Yes. Now, Milords, there are 2 aspects of the matter, Milords. The issue before my lords is this, Milords, that as to whether the employee concerned is entitled to the benefit of the old pension rules when he was regularized after the new pension rules came into effect. Now, Milords, there are certain matters in this batch, Milords, which have been decided on merits, Milords. And most of the other matters have been dismissed on delay, Milords. Now, a batch of matters in which matters are dismissed on delay, Milords have already remanded those matters back to be reconsidered by the High Court, considering that the financial implications involved. Right. I must point out, however, Milords, as I said at the outset, Milords, in this batch, Milords, about 5 or 6 matters are there, Milords, which have been dismissed on merits against this statement.
Right.
To that extent, Milords, if Milords permits me, I can place a chart at least giving outlining which are the matters dismissed on delay, which are matters dismissed
No,
on merits.
we'll, so far as the matters which are dismissed on the ground of delay,
Please, minutes.
so that will follow the
Very
route
good.
that we have
Very well.
followed.
I
Isn't it?
may just place
Are
the
the
note.
respondents represented we'll just take out the cause
Item wise.
item wise.
Yes,
Item wise.
yes.
Where you say it is dismissed on merits,
Yes.
that will be kept aside.
Yes,
Where otherwise it can be, order can be set
That's
aside
right.
and remitted, it will be remitted.
that's right. Minutes.
And which is the order? First hand us the order that is to impart in the
Yes,
matters.
Milords may just hand over the order where Milords have
Yes.
already remanded the order.
Yes.
Matters back.
Can we have a copy of that, please?
Yes, of course.